In 2016, IBC or Insolvency and Bankruptcy Code was introduced as one of the biggest insolvency reforms in the country. This move was also extremely timely because it came at a time when the Indian banking sector was struggling with an NPA crisis, which exerted immense pressure on bank lending, increased the cost of capital, and it also made it extremely difficult for small businesses and individuals to get loans. Enter IBC as the hero. It came with the promise of rectifying all of this and consolidating and harmonizing the scattered bankruptcy laws across the country. Cut to now, we've seen that India has gone up from 142 in 2014 to 63 in 2022 in the ease of doing business rankings, and a lot of credit for it is often given to this law. What this also means that with this law comes a lot of hope for far-reaching consequences and far-reaching impact on India's growth and development. Now, what does this law exactly say, and is it actually well equipped on the ground to turn all of these hopes and ambitions and dreams into a reality? These are some of the questions that we'll be discussing in today's episode of Laws of the Land. For this episode, you have me, Apoorva Mandhani, we have with us Bhadra Sinha, and we have with us Supreme Court Advocate Swarupama Chaturvedi, who's also a counsel for IBBI. She's also a former faculty at NLSIU Bangalore. So she's actually the best person that we could have to discuss this with us. Thank you so much for joining us, Swarupama.
Thanks for having me, Apoorva. Bhadra, it is nice. The law, as you said, it's not often given credit, it must get the due credit.
Right.
Because this is not only reform in insolvency law, it is basically reform in complete economy related laws. So when we talk about Insolvency and Bankruptcy Code, IBC, it came at the time of crisis. Business was going on, and as you rightly said, it was about the NPA issue. But other side, which I want to share with you, it's not only solving the problem of NPA and helping the bank, it is also here to solve the problem where you take wrong business decisions, like business failure. How NPA comes? NPA is somewhere you have taken credit and you are not able to pay, and because of various reasons, including the loss in the business, which is main reason. Loss of business is not always due to some bad thing. Often it does happen, PML, etc. are example to that, but most of the time you might have taken a wrong business call. Now, as much ease of doing business is related with entering into the industry, getting the credit, starting the business, government has realized freedom to exit is equally important to solve the problem of NPA, as well as freedom to exit should be and must be connected with ease of doing business. So this is where this law has come. It was, of course, the history goes way back. I mean, we had laws in some presidency towns, and then in 2001 itself, Reserve Bank has constituted an advisory committee to see that how the insolvency law can be brought in the scene. 2005, the committee has come. There were series of experiments and exercises were going on, but the substantial step was in 2014 when BLRC came.
Yeah, so Swarupama, just to ask a very pinpointed question, why was the need felt for this law, and what exactly did this law change?
So one thing, the need, because there was no law which helps to wind up in no time or revive the company. So there was no insolvency law which can be applicable on complete industry.
So was there a vacuum? This means
Yes.
there was a vacuum,
Yes.
and this law actually filled that vacuum legislation.
So there was a vacuum, and whatever provisions we had, like it was being dealt by Companies Act, the winding up, then SICA, there were multiple small provisions in different scattered provisions, I would say. So yes, the correct fact is there was vacuum, but at the same time, there were different scattered laws to deal with the problem of industry and the NPA. So this law came to consolidate all that and fill that vacuum where the message should go internationally that yes, you can come up with investment and you have the opportunity where your economy is insured. Like the problem was when you are in business laws, you can't return. So bank was also open to give credit because there is a law which deals with that situation. Investor is also better placed that, okay, I can take risk, I can invest, and if it can't work out, I can make exit.
Right.
So the economy was secured for creditor and debtor
As well
both.
for the investor. Okay.
And one more important thing which this law has brought, where you can say that it was absolute vacuum. So when we talk about insolvency, till now what I said, it was about creditor and debtor. So debtor means we presume that the one who has taken money for investment. There is one category which is brought by this law, operational creditor. Now, the operational creditor is the person, for example, you are doing business, you have taken money, so debtor creditor is there. But there are many such vendors who provide services or who supply raw material. These categories of people whose money is stuck had no other remedy till this law came into the force. So the basic and the most important contribution of IBC was giving option and solution to operational creditor. And interestingly, when we analyze the journey of this law, most of the IBC trigger is by operational creditor rather than the financial creditor.
Okay.
So while law came for financial creditor to presume with, but actually it has contributed mainly to operational creditor.
So since you mentioned options and solutions generally, for our viewers, briefly, I know it's a very long, complicated law, but briefly for our viewers, if you could give them a few examples of the sort of provisions that this law contains, the sort of options and solutions that it actually provides.
So when we say financial creditor, so I would not go into sections, etc. But then there is a provision that if you have given money for some business and your money is stuck, you need to give demand notice. If the debt is accepted, that yes, there is debt and I need to pay, but I'm not getting paid, I can send statutory notice to that person and then I can file application to trigger the insolvency. This is one category for financial creditor. Second, I have supplied product to the company, still it's due, and again the debt is not disputed. I'll explain why, how it is should be disputed, and it is admitted debt. Then that person can also trigger, the supplier, that person can also trigger, person or company. When I say person, it includes company, etc. So now this definition of debt, claim, default, everything was being interpreted by courts. In last 5-6 years, everything has got settled. Why I say 5-6? Because in COVID time, it was suspended also for some time. So I'm not counting that period. So when it started, applications have been started getting filed. All these terminologies, when you call it, it is default. When you call it, is debt. When you call it the claim as claim. So all these things got settled by the courts. So the important part is that there has to be an amount which is due. That due has to be defaulted and then it is not disputed. Disputed, for example, if I think that my due is there to other side, but other side think that no, I have provided. So if the dispute is being created, then again adjudicatory authority, which is NCLT in IBC. So the moment the application will be filed, that person has to come and defend that, oh, it is disputed. And then A will pass the order. If the application is admitted, then a new class of professional was introduced by IBC, Insolvency Resolution Professional.
That is in the case if it is
IRP.
admitted, if
So,
there is no dispute over the debt.
Yes. So once it is admitted, in the admission order itself, there will be name of an IRP and that person would be like replacing the management. So complete management will get replaced by the IRP and within 30 days, that IRP will send notice, account, etc. will be closed. The procedure will be triggered from that day. And then within 1 month, the IRP is to be confirmed by COC. COC is Committee of Creditors. So the moment IRP is appointed, he will publish, invite claims, and then the COC will get constituted. And they will confirm. They can confirm the same person. They can replace, they can suggest some other person. All this happen. And then again for appointment also in operational creditor and financial creditor, there are different provisions. I would not take into complicated
So which
law.
means that when there is no dispute over the debt, then there is a possibility as far as the revival of the company is concerned. Is it so? The company which goes in for insolvency.
So there are pre-amendment and post-amendment situation. So initially it was very simple that there is debt and then A will pass order, adjudicating authority, and then company will, insolvency will be triggered. Then the situation comes with experience. It was realized that, okay, by certain reason, some default has taken place, but that now stake is too high that the company wants to settle the matter. There was no provision for settlement. And then matters started traveling from NCLT to NCLAT, Appellate Tribunal, and then till Supreme Court, because NCLT and NCLAT did not have that power that they could, because there was no provision for settlement. But then Honorable Supreme Court has passed orders under Article 142, and then the settlement was allowed. And in one of the order, rather, there was observation also that ministry should look into that. Then amendment came, which has got provision that you can settle. So even if it is first notice for admission is issued, at that stage also there is a specific stage one can settle the dispute.
So since we're talking about amendments, pre-amendments and post-amendments, our next question is, of course this law is very young, but over the last 7 years we have seen multiple changes, multiple amendments. What is the reason behind it?
So anything when new starts, with experience we learn. And this is how, like in all over world, we had insolvency laws. We had failed provisions, SICA and everything. And when we brought up the law with expert committee reports, etc., with international experiences, we tried to bring best of everything. But then the moment it started getting triggered, as I told you to begin with, like I don't think anybody has expected operational creditors to come so forward and trigger most of the insolvency things. Now, with experience, many things got realized, and provisions like the settlement, provisions like related party issues, because whenever law comes, there is always some scope for mischief as well, and many things cannot be realized until you go through the experiences.
Right.
Having the financial stake and objective of IBC is very clear: to revive the company. The company has to be ongoing, and that is where the IRP role comes in. So the difference in between other provisions where the company is in the problem and recovery, etc., that's totally different than the IBC where company has to go on. And a new person who is till that moment it is triggered is completely outsider, is supposed to run the company. So many times, many situations occurred which made lawmakers also perhaps to think that, oh, this was not thought of. For example, the settlement, when issue came, it was realized if the objective of the law is to let the company go on, then if there is settlement possibility, then why not?
Why not?
Right.
So that is how many provisions came. Like first is settlement, then second, the burning example was home buyers. I being a person,
ask you that question also.
Yeah.
You know that I think one of the major changes which came into the law, which was introduced in the law, was inclusion of home buyers.
Yes.
So, and that was subsequent to several cases pending in the Supreme Court over these real estate projects and real estate companies. So if you could just highlight on that as well.
So when IBC started, and financial creditor term was always related with the bank. Bank is financial creditor. And that was a time when, if I recollect correctly, first was the JP issue. And the petition was filed, and in Supreme Court, Chitra Sharma case comes, and the issue was that treat us as financial creditors. So till that time, legal provision, as I told you, many terms were keep getting interpreted and defined by the court. So that time by Supreme Court, home buyers were treated as financial creditor. But as we talk about it in few seconds, it took hours and years in the court. I still remember my first appearance for IBBI was into JP issue only in Allahabad and CLT, where many issues were there before adjudicating authority, where they wanted assistance from IBBI to get it interpreted. So like that, even authorities were facing the situation, how to interpret which law, because except Supreme Court, nowhere we have 142 where court could do that. Right. So some assistance was required. So when issue of home buyers came, so first was of course to treat them financial creditor. Now treating financial creditor means what? Giving liberty to trigger the insolvency. Now, in one project, there are hundreds of home buyers. Giving power to trigger the insolvency because they have also invested their money was something like it was discussed and it was considered appropriate. Now, right or wrong, law was being settled. Now, after a while, it was realized if there are thousands buyers and one could go and just trigger it, it was again stopping the project.
That's right.
Because every positive thing had negative impact. So the moment you trigger, complete civil proceedings stop, management is replaced. So, complete company goes through a process. And I'm talking about the time it was all going parallel when home buyer can be financial creditor or not, and at that time settlement was not the option. So
These early days.
It was early days, and later on this settlement issue has come up. So JP issue, Amrapali, which was in Bikram Chatterjee, that case is still pending. So all these cases gave opportunity to courts to discuss and decide these important issues, and the home buyer was definitely one experience. I'm sure nobody had thought that there would be a situation where thousands of people could be eligible to trigger. And that's why the percentage was to be decided. Many subsequent developments has happened. Even in beginning time, 75% of voting in committee of creditors was required to pass any resolution plan. Resolution plan is like new plan for the company.
For the revival of the company.
For revival. So with experience, it was realized that there was no possibility to get 75%, and many resolution plans were not in the position to get accepted. Again, the purpose of the code was getting frustrated.
Right.
So that percentage was also reduced. So, with experience, with practical difficulties, these things have started getting changed. Now, at this moment, I must tell you that anybody who's home buyer, now it's financial creditor and they can trigger the insolvency process.
So can they also participate?
Not one person. Just
not one person. Okay.
Minimum 10%.
Okay, 10%.
Minimum 10% of the home buyers are required to trigger the process.
And can they also participate in the COC proceedings at the Committee of Creditors proceedings?
So they used to participate, but they did not have voting rights.
Okay, so they can participate, but
they can have one IRP also for them to assist, but the voting right was not there.
Right.
Yeah, but that time even individual was ready to could do that. But now at least it's settled. Otherwise, complete business was getting on halt. So the law came to facilitate the business. I mean, the problem was in initial days. What I have felt even while appearing before the courts, that IBC was being treated even by our colleagues as a recovery mechanism, which is absolutely not the purpose of IBC.
Right.
It is not recovery mechanism. For recovery, you have different civil laws and you can go for it. It is just to facilitate
more of a revival mechanism.
That company, that business has to be revised. It is not for the money which you are losing or I'm losing. No, it is for that company which is an independent judicial personality. So you can say in one way that IBC is there to help that legal personality which was not taken care at that time, and it is while balancing interest of all stakeholders.
Right. So you've mentioned now that, and you've emphasized on the fact that the law was brought in for revival of businesses, for resolution, quicker resolution. And because of this, one of the major pointers was also the time frames that they have set up in the law. What has been your experience with these time frames? How are they being adhered to? What are the sort of difficulties in adhering to them, if you could tell that for our viewers?
So, it was difficult. I mean, in most of the cases, we see that timeline is not being followed.
I guess there were teething issues also, maybe because new laws and everything.
Yes, I'm coming to that. So, most of the time, as I told you, to begin with, people were considering it as just like, their recovery process. Timeline, even professional, IRP was also new professional. IBBI was established at that time itself. IBBI, the way they have performed was commendable. Like the new body coming up, a new law coming up, take examination. Every Sunday they used to take examination, have new professional, train them, and then make them work, and that followed the timeline. So everything was absolutely challenging at every front. But I think that wasn't the reason for delay. Most of the reason for the delay, which in my experience I have seen, is about litigation. I have written one article, litigation tool or weapon, because it was definitely tool, because that has helped to interpret and understand the law. And Supreme Court has done absolutely commendable job in settling the law and finally even upholding the constitutionality. But then at the same time, these things were delaying the process as well. Although in technical term, time taken in litigation is not to be counted, but it was being delayed. So at one scene, you want something to happen in that particular timeline, but at the same time, every step was being questioned by some or other stakeholder.
Right.
So in my personal view, litigation was one biggest reason, and it is biggest reason in wherever it is getting delayed. Sometime in some cases, of course, like it was recent issue about less benches available and infrastructural issues.
That is one of our questions, which will be.
Before we get to that question, though, since Swarupama mentioned her article, we'll get her to share that article's link with us, and we'll put it in the description so that all of you can go check it out, read it.
So since Swarupama, you've just spoken about NCLT, that is the tribunal that was constituted under this IBC code. Just want to ask you one thing, because we have often come across a lot of cases, where applicants have spoken about manpower crunch in these tribunals. So what are the infrastructural issues that are plaguing this entire system of IBC?
So I have been appearing before many NCLTs from Ahmedabad, Kolkata, Allahabad, Delhi, everywhere. And what I have realized, everywhere the NCLT premises is not in any court, and it's like somewhere in some government building. So when you begin something, I think these things are basic challenges before government. And infrastructural issues, not only in terms of manpower, in terms of physical infrastructure was also there. Like if I talk about Delhi, NCLAT or NCLT, the hall used to be like, lawyers cannot be fit into, where the litigation and cause list used to be huge. So once the law is new, government came up with the criteria that, okay, these are the people qualified to become members, and then their training and everything. The law to handle, with the speed you can handle the law, where you have already have been handling. Most of the cases, members were retired officers. So I think, dealing with the new law, that transition also took a bit of time, because the difference in between IBC and other laws which comes up and, you just pick it up. Every law has some or other base from where you start, like either criminal law, civil law, corporate law. When IBC came, IBC had an absolutely new structure. Everything was new. So for advocates as well as bench members, for everybody, I believe, it is my personal view, that while everybody knew basics and was quite equipped to deal with that efficiently, the time required to deal with that, from IRP till advocates, bench members, everybody, it was taking a bit of time. So I think it is temporary phase, and settling any new things takes a bit of time. And if we assess overall and presume the act having 250 plus sections and changing 13-14 laws, having prominence over all laws, and then bringing such a huge change which was like completely different than whatever we had, these limitations are very small ones, and I would rather say that they have really done a good job in dealing with that situation. There were limitations, yes, and it is still perhaps there, but I think efforts are going on and it should be sorted out soon.
You just spoke about prominence of IBC. So there is a very, there's an issue which is pending even in the Supreme Court over, which is actually seen as a tussle between the IBC and the PMLA, which is the Prevention of Money Laundering Act, because it is often noticed that once the IBC is triggered, proceedings under IBC is triggered, often the enforcement directorate, which actually, enters into the criminal aspect of the business conducted by the company, initiates proceedings under the Prevention of Money Laundering Act. And as we all know, under the PMLA, properties get seized and attached. So I believe there are a couple of cases which pending, although they're pending in the IBC, but due to the PMLA proceedings, the IBC proceedings get stalled. Since the assets get attached and seized by the ED, the resolution or the revival of the company literally freezes because of that. So, and it is said that, both these agencies, both these laws are handled, of course, they come under different ministries of the government of India. So what is the reason? Why can't these two ministries get together and sort it out? Because after all, one law is kind of affecting the other law or the procedure under the other law.
So I'll take it in a different way. There is no difference or problem in between two ministries or any conflict in between that. There is interface, because IBC is very clear that when IBC is triggered, every civil proceeding will be straight, but the criminal proceeding can go on.
Okay.
So when it is very clear, then there is no conflict with any law which is dealing with criminal aspect of the corporate thing. Now, PMLA has very clear provision that it's not the individual only, it's the proceed of crime is also an output which cannot be left. Now, when you say IBC's objective is to maximize the asset value and revive the company, absolutely understandable. At the same time, when a criminal law says that the proceed is crime, I don't see any conflict in between both. Okay. It's just matter of time. I'm sure Supreme Court is going to settle this law, this provision, but interface doesn't mean conflict.
Okay.
Right. There is interface, and the proceed of crime, wherever that asset is, that is being freezed by the ED, which is well within their power. And just because something is seized and freezed, IBC cannot go on is also not correct way of looking at. You can say the asset value would be reduced because, every company has so many assets.
Okay.
Mm-hmm. It may not be the 100% asset is what the ED is seizing. So the maximization of that asset could be reduced because of that. But then if something is criminal angle is involved and it is a proceed of crime, we cannot say that just because objective of IBC is to maximize the asset value, that criminal proceed can be excluded or included in that asset value. That is not the right thing.
Harmonious interpretation is what you're looking at.
Yes, it has to be.
Right.
So I don't see any conflict, and it is not about two ministries settling it because there is no conflict at all. IBC is very clear that criminal angle is excluded. The moment the provision is there, there is no conflict.
So there is no bar as such. If the IBC proceedings begin,
both can go on.
Both can go on parallelly. And as you said, if the assets have been attached by the ED, then the maximization of that asset or the value of the asset can be
that may be affected, but that's the outcome of if there is some criminal angle, it cannot be excluded.
Right. Okay, I'll just take one more question, and this is about a word that has been in the talks ever since IBC came about and IBC spoken about, and the word is haircuts. Yeah. We have to address that. We have to talk a bit about haircuts. Now, huge haircuts are being spoken about. It's an issue of discussion. What do you infer from these haircuts, and what sort of impact or stresses do they put on banks generally?
So I will connect this with the last discussion which we were having about PMLA. So for example, if PMLA is already under operation and most of the assets of one company is seized under PMLA, then the asset which was supposed to be with company, if it was not the illegal asset and outside proceed of crime, it could have been higher, and then the hair could have been lesser. Now the moment that asset goes, that also gets reduced. Then the delay in proceedings, this litigation cost, IRP fee, everything which is costing the CIRP comes from the company value.
So it contributes to that.
It contributes to that. So there are various reasons to the haircut, and of course delay is one of the reasons.
Okay. With that, we've reached the end of this discussion. As we discussed, the law came about with the objective of revival of businesses, of, keeping them going. Of course, there have been teething issues, but as Swarupama said, the law still comes with a lot of hope, and it should probably be given credit where it's due. Thank you so much for joining us for this, Swarupama. I'm sure our viewers would really appreciate this discussion. And as I always tell you guys, please let us know in the comment section what you think about the video, and if you have any law that you would like us to discuss and take up, always let us know that as well. Thank you so much for joining us.
Thank you.
Thank you so much.